Please, Your Lordship, I'd like to mention item number 6. Praying for 2 weeks' time as the conducting counsel, Mr. P. Nongbri, is not keeping well. Just inform the other side as well.
Yes, who's for the other side? You're in this case?
Yes, Your Honor.
Pray Smith for adjournment. Mr. Letter Counsel has sought for adjournment of this matter on the ground that the Learned Conducting Counsel, Mr. P. Nobri, is indisposed. Accordingly,
on behalf of respondent number 6.
accordingly, on the same not be objected to by the respondents present, that is adjourned. List the same after 3 weeks.
I oblige, Your Lordship.
My lord, I beg to mention item number 3, my lord. After a week, my lord. After a week.
Really rehabilitation. Mr. Paul also.
On plea made by the petitioner, Ms. The Learned Counsel has sought for accommodation in this matter on the ground that the Learned Senior Counsel, Mr. K. Paul, is in bereavement. The same not be objected to by the respondents, but is adjourned. List this matter after 2 weeks.
Item number 5, Your Lordship.
No one is asking for time. Why?
Your Lordship, actually here it was fixed for instruction that whether we will go for hearing and we will withdraw. So we will opt for hearing, Your Lordship, here.
What is this matter about?
It's a service matter, Your Lordship.
So, 2 weeks. We'll go for hearing.
2 weeks, Your Lordship. 2 weeks, Your Lordship.
You are the counsel in this case.
I am the counsel, yes, Your Lordship.
So if you are prepared for hearing, matter is posted for hearing,
Yes, Your Lordship.
then we will start with the hearing.
Yes, we will do after 2 weeks. After 2 weeks, Your Lordship.
Okay, we'll try to finish next day at least. Mr. S. Kumar, Learned Counsel, appearing for the petitioner, has sought for accommodation. Is there any specific order in this regard?
No, nothing, Your Lordship.
Sought for accommodation in this matter? Praying that this matter may be, that he's not ready to be heard today, and has prayed that the matter may be heard after 2 weeks.
Deeply.
Same not be objected to by the respondents. Pray aloud. List this matter accordingly.
Deeply obliged.
Daily list item number 1. Kindly post this matter at the end of the board because the conducting counsel is on.
What is this matter about?
It's a bail matter. Yeah.
It's a bail application, my lordships.
Is it POCSO matter or what matter?
NDPS.
Lordship, I don't have the records with me.
What is the stage of the case?
For evidence, Your Lordship.
Evidence.
Yes, Your Lordship.
How many witnesses are there? How many?
8 cited witness till.
And how many examined?
Not yet. Not even one.
Not even one. When was the charges framed?
Charge was framed on the 30th of September 2024.
Excuse me.
Lordship, kindly, end of the board.
Let us see. This is only posted for motion. If matter is required to be heard, it will be heard. If not, then we can post it for hearing on the next date. 21B.
Yes, my lord. 21B and 29 in the Affairs Act. Intermediate
Intermediate.
condition.
Extra copy.
How long have you been in custody?
More than 8 months, Your Lordship.
Let me just go through.
Yes, Mr. Guru, you in this case?
At the juncture, my lord, I'll take notice on behalf of the state, all the respondents, my lord. Let it come up tomorrow or day after. Take care.
Any additional thing required apart from this, whatever is there in the petition?
I don't think,
Charge sheet has been annexed.
Yes, I have annexed charge sheet, my lord. Lord, if you consider only 2 here today because I came all the way from Cleariat, so I have another case. So tomorrow, so maybe by hearing, maybe by today itself, my lord, may consider.
You have gone through the petition, Mr. Guru.
I got it just now. That's it. I'll go through, we'll have it.
We'll take it at the end of the board.
Yes.
Let me just go through.
All right.
Item number 2.
Okay, done. अच्छा, हाँ.
I told her to get the copy of this order and produce it to the judge concerned, so that हमारा पास दिन में कौन सा कोर्ट है क्या है. Give me.
So I made the observation that it is not mandatory for the victim to be made a party in an appeal.
Lordship.
Only on his or her own volition, she chooses or he chooses to participate, then that option is there. The trial court is bound to,
Lordship, correct. Yes.
to allow that. Though I think I made certain observations how it is to be done. The victim may prosecutor for the matter can participate, but only to assist the prosecutor.
Or prosecutor, yes. That's the correct
To
position.
that extent. Otherwise, you cannot jump in and take control.
Lordship, absolutely.
So I think that who's appearing for the victim?
In this case,
we had not agreed it.
We haven't.
Oh yes, yes,
We
sorry.
had not agreed.
So in the middle of the hearing, this issue cropped up, and Lordship said, "Let us address this issue, and then we'll proceed with the hearing."
As as I've stated time and again, as far as the other part is concerned, with regard to bail,
The law, the statutory law is taking care of that.
so that we will consider in another.
Another matter.
Enlighten now.
Enhancement. Sure, we can't further enhance. The battery is not charged. उसको नहीं बोलेंगे.
Thank you.
Oblige, Lordship.
You can go for the order.
Lordship.
Item number 7.
संजय सिंह कौन सा है?
My lord, this is the fourth bail application for this accused person before this honorable court. My lord, this accused was arrested on 24/5/2023 from the taxi, and it was alleged that contraband of ganja was detected from a forested area in the district of Rivoi, and it was alleged that he is involved. This particular accused, your lordship, this particular accused was accompanying his brother, who was taxi driver and was carrying two passengers, and the custom officials, they apprehended this person from the roadside, and they said that contraband has been detected in the forest and they are involved, so they were arrested and accordingly remanded to judicial custody on being produced before the trial court. My lord, after 6 months, final complaint was filed. Nothing was recovered, nothing incriminating found from them. Even your lordship, they have said in this complaint that there are phone link in this for this particular accused. Only for this particular accused, phone link was there, but CDR they have not produced in the charge sheet. And even your lordship, the previous bail application, your lordship was directed to furnish the CDR. They said that there is no CDR. So that means CDR is not available on record. Only an averment is made that CDR is there, but there is no such CDR. As of now, nothing is there. Now my lord was pleased to reject that bail application on the ground. It was rejected by this honorable court on 17/5/2024, almost 10 months back, on the ground that there is link of this accused person and there is connection between the main accused, who is said to be involved, but there is also no evidence, your lordship, that that said person who is the mastermind as alleged by them, in fact kept that ganja there. There is no such evidence, but there is just oral assumption, and that Lordship was pleased to reject that on that aspect, although there is no CDR. Now, my Lord, I have come before this Honorable Court because the accused persons are, this accused person is behind the bar for 1 year, 9 months and 18 days, almost one year, 10 months, almost 2 years, my Lord. And final complaint was filed on 2023. And my Lord, even though there is charge sheet has also not been framed, what to speak about the evidence of the witnesses. My Lord, keeping the accused person behind the bar for several months and delaying the trial is unfair, Your Lordship, and is violation of Article 21 of the Constitution of India, Your Lordship. My Lord, only on this ground, Your Lordship, I have preferred this bail application, Your Lordship, because there is no Your Lordship, progress.
How many? What is the stage of the case?
Charge has not been framed, Your Lordship, even after 1 year of the framing of the submitting of the charge sheet. And only on this ground, Your Lordship, there are 10 witnesses cited in the examination. Even the charges has not been framed, Your Lordship. There is no prospect in future that, Your Lordship, trial will conclude soon. On this aspect, Your Lordship, I have enclosed some certain judgment of the Honorable Supreme Court, Your Lordship. And my Lord has also, in some cases, although it is POXO cases, but my Lord has taken note that delay in the trial and the accused person behind the bar, that has to be balanced. My Lord, in this particular case, Your Lordship, I will just place this one citation, my Lord. Where, my Lord, in this case, Your Lordship, the accused was behind the bar for 1 year and 7 months. My Lord, paragraph number 6, page 2. This is also an objection was there, Your Lordship, that section 37 barred, but Your Lordship, the Honorable Supreme Court was pleased to consider and stated that taking into consideration the fact that the petitioners have been incarcerated for a period of almost 2 years and the trial is not likely to be taken for hearing in the immediate near future, we are inclined to grant bail to the petitioners. So, Your Lordship, bail was considered. And in my application, Your Lordship,
This case has also, you see, there's also consideration on ground of parity.
yes, Your Lordship. So, parity, Your Lordship, parity, but the main concern, I have another judgment, Your Lordship, in page number of my 59, Your Lordship, my petition, I have enclosed.
$59.
Yes, Your Lordship.
Yes.
In this case, Your Lordship, 59, page number 60, Your Lordship. During the course of hearing, we are informed that the petitioner has undergone custody for a period of 1 year and 7 months as on such and such. The trial is at preliminary stage as only one witness has been examined. In my case, not even a single witness. The petitioner does not have any criminal antecedent. Taking into consideration the period of sentence undergone by the petitioner and all the attending circumstances, but without expressing any view in the merit of the case, we are inclined to grant bail to the petitioner. Similarly, Your Lordship, in page number 61, the Honorable Supreme Court, Your Lordship, has held that, paragraph number 2, taking into consideration the fact that the petitioner is reported to be in custody since such and such and has suffered incarceration for over 1 year 6 months, and there being no likelihood of completion of trial in near future, which fact cannot be controverted by the learned counsel appearing for the state, we are inclined to grant bail. Similarly, in the other case, Your Lordship, page 64, last paragraph, Your Lordship, considering the fact and circumstances on record and the length of custody undergone by the petitioner, in our view, case for bail is made out. This, he has gone almost 2 years, this particular accused. And the last, Your Lordship, page number 66, this is also for all the citations, Your Lordship, for commercial quantity. Page number 67, Your Lordship. Paragraph number 3, we have heard learned counsel for the parties and carefully perused the record. The investigation is complete, charge sheet has been filed. Though the charges are yet to be framed, the conclusion of trial will thus take some reasonable time, regardless of direction issued by the High Court to conclude the same within 1 year from the date of framing of charge. The petitioner do not have any criminal reason. There is thus substantial compliance of Section 37 of NDPS Act. In such circumstances, but without expressing any view on the merit of the case, we deem it appropriate to release the petitioners on bail, subject to the terms and conditions as may be imposed by the trial court. My lord, in all these cases, your lordship, these petitioners had been incarcerated for below 2 years, and in some cases 1 year and 4 months. And in similar circumstances, I am also placed, your lordship, because my case is also similar, because I have been incarcerated for almost 1 year and 9 months, 18 days, and even the charges has not been framed. And that's why, your lordship, I have preferred this application for bail, grant of bail only on ground of delay.
Yes.
Your Lordship, first of all, I would like to submit that the matter is fixed on 13th of this month, Your Honor, that is day after tomorrow, for framing of charge, Your Honor. So there is every likelihood that charges will be framed on that day. And Your Lordship, with regards to delay on trial, order for framing of charge has been passed by the learned trial court on 21st of October 2024, Your Lordship. Thereafter, Your Lordship, the prosecutor, he has resigned since he has been appointed as in some other post. Immediately, the customs officials, they have appointed another special PP, Your Lordship, and the files were being transferred to him, so it took a month's time, Your Lordship. Thereafter, winter vacation started from December, and the court was on leave, which has been reflected in the orders of the trial court. And in February, that court went for training, Your Lordship, the learned district judge. So thereafter, for that ground, after this order was passed for framing of charge, so the matter could not be taken up, Your Lordship. So it's fixed day after tomorrow for framing of charge, Your Lordship. So I humbly pray, Your Lordship, at this stage before charges are framed, since that learned trial court has already come to a conclusion and reflected in the order, Your Lordship, I have a copy of the order, that there is a strong prima facie case against the accused persons, Your Lordship, that they are involved in the instant case. So, Your Lordship, if bail is granted to them at this stage, it would be very difficult if they abscond, Your Lordship, to apprehend them, since charge is not yet framed. And this person, being a resident of Shillong, he may influence the independent witnesses, Your Lordship. It will be very difficult if he influences them or intimidates them, Your Lordship. Once the charge is framed and the evidence of the independent witnesses are recorded, Your Lordship, thereafter Your Lordship may take into consideration any bail application, Your Lordship. This is my humble submission, Your Lordship.
What is the order, sir?
Yes.
heard Mr. S. Pandit, learned counsel for the petitioner, who has submitted that the petitioner is the accused himself. Petitioner is the accused.
Petitioner is the brother of the accused, Sujit.
of the accused.
Yes. Sujit Kumar Rai.
Who has submitted that the brother of the accused,
Sujit Kumar Rai.
the brother of the petitioner, Sujit Kumar Rai, is the accused, is one of the accused person in criminal NDPS under bracket NDPS case number 8 of 2023, pending for the court of the Learned Special Judge NDPS at Nongpo, Ribhoi district. The Learned Counsel has further submitted that the accused person in question was arrested in connection with
Custom seizure case number.
where is the
In the, my lord, in the cost title, page number 1. Custom seizure case number.
custom seizure case number 01 page akan ni kat you mah ni first page tu, which case involves and which case refers to an incident of search and seizure of interception, search and seizure of a local taxi bearing registration number ML05Q 6794, wherein the petitioner was one of the passengers in the said
Passenger, he was brother of this driver. He was the brother of the driver who was accompanying.
but he has accompanied him. Petitioner was the
accused.
cousin brother,
Yes.
cousin brother,
Yes.
cousin
Accused
brother,
was cousin brother.
cousin brother of the driver who of the said vehicle, and from which vehicle alleged contraband substance under bracket ganja of 149.550 kg was discovered
My lord,
and seized.
sorry to disturb, my lord. This was not detected.
Sorry,
from, yes.
sorry.
It
Yes.
is from
This from that place.
forest, not
I
from,
remember this case because you have
Yes, yes,
come.
yes, yes.
Was discovered
From forest
and
area.
seized from a forest area at Liarbang, Ribhoi district, the accused person, the occupants of the said local tourists being linked to the said, to the seizure and to the discovery and seizure of the said contraband substance. Accordingly, on the case being registered under the relevant provision of the NDPS Act, the accused person in question, along with other co-accused person, were arrested. On the charge sheet being filed, the investigating officer has come to a finding that a prima facie case is well made out against the accused person in question, along with the other co-accused person, and under the relevant provision of the NDPS Act, and they are directed to be tried before the trial court. The stage of the case is now for framing of charge, the London trial court having on consideration of charges having come to the conclusion that the accused person in question along with the co-accused person are to stand trial for the said offence alleged. Next, it is the further submission of the Learned Counsel that at this stage, though there is no evidence whatsoever as far against the accused person in question, the fact that he is in custody for the last
1 year, 9 months and 18 days.
1 year and 9 months plus, the trial have not been proceeded expeditiously. Therefore, on the ground of prolonged delay in the trial, the petitioner have made a prayer before this court for grant of bail to the said accused person in question. Next, stressing on the point of prolonged delay trial, the Learned Counsel has referred to a number of cases wherein the Honorable Supreme Court on this ground, that is on delay of the trial and the accused person being in custody, therefore bail was granted even without going to the merits of the case. In this regard, reference has been made to the case of what is the first case that you have
First
referred to?
case is Man Mandal and another.
Page?
In the loose sheet I have given you lordship, first case.
Man Mandal and another versus the state of West Bengal. Wherein the Honorable Supreme Court, by order dated 14/9/2023, in special leave to appeal under bracket CRL close bracket number 8656/2023, had observed that. Where is the relevant observation?
Paragraph number 6.
Had observed as follows. I can paragraph 6 more. Another case cited is the case of, where is that case where you said the charges have not been framed, therefore
Yes,
he
Your
was,
Lordship.
Kunum to mo?
Yes, in page number 67.
Hassanu Jaman and others versus the state of West Bengal. Can you speak any page 66 more? Kunum to mo? In another Hassanu Jaman. Wow. Where it was I to mo? Para wherein at para 4 and 5 of the same, the Honorable Supreme Court has observed as follows. It is therefore prayed that this petition may be allowed and the accused person may be enlarged on bail with any condition as deemed fit and proper to be imposed by this court. Per contra, Mr. Leonard Counsel for the respondent, Union of India, has opposed the prayer made in this petition and has submitted that the case has proceeded in its normal course before the trial court. In fact, charges are slated to be framed on the 13th March 2025. The Learned Counsel has, however, admitted that the trial court, by order dated
2110
21/10/2024, had fixed the matter for framing of charge, but because of certain intervening circumstances, such as the resignation of the then PP, the presiding officer of the court being not being available because not being out on training, and other reasons, including the court vacation. But even
Court vacation, there was no court vacation, my lord.
because criminal cases will
Date was also fixed. Dates were also fixed.
and other, therefore the charges could not be framed. Next, the second leg of argument of the Learned Counsel for the respondent is that the accused person, being he is a resident of Shillong.
Yes, Your Lordship.
Being a resident of Shillong, there is every likelihood that he may tamper with the witnesses or intimidate them, and there is also the possibility that he may abscond if enlarged on bail. As such, the prayer may not be allowed. That is your submission.
Your Lordship. Your Lordship, there is also a bar under Section 37, Your Lordship, which Your Lordship has clearly discussed, observed in the previous bail applications, that reasonable grounds, what reasonable ground means, and to come to a conclusion that there are reasonable grounds to find out that they are not guilty at this stage. Your Lordship has already discussed in details in the previous bail application, Your Lordship.
The learned counsel has again stressed on the fact that since Section 37 of the NDPS Act is applicable in this case, the seizure of the contraband substance being of commercial quantity, therefore, since no reasonable grounds has been cited to strengthen the case of the petitioner as far as his guilt or innocence is concerned, this court would therefore incline to the fact that the presumption of guilt is to be adopted, and accordingly, under such circumstances, bail cannot be granted. Next, this court has carefully considered the submission made. The merits of the case need not be gone into at this stage, since the same are before the trial court for consideration. The fact that the accused person in question has been made to stand trial would only emphasize his complicity as far as the case is concerned. Have you made any vermin as far as his antecedent is concerned?
Residence, my lord.
Antecedent?
Antecedent, there is no antecedent. I have stated.
Antecedent must be there.
Yes, there is
Antecedent must be there, either criminal antecedent or otherwise. How can you say there's no antecedent?
no criminal
What does
antecedent. Is
antecedent
not there. Criminal antecedent is not there.
Nobody can have a
Yes.
a blank background.
Yes, my lord. There is no criminal antecedent I have mentioned here.
Have you mentioned where?
Yes. In paragraph number 13 of my page number 8.
Kunum Tukau? It is, however, the contention of the learned counsel for the petitioner that the accused person in question has no past criminal antecedent, meaning that he has not been involved in any criminal cases or charges. The fact that the accused person is also has also been in custody for almost 2 years, barring a few months, has also to be taken note of by this court. Since on this premise a number of decisions have been rendered by the apex court to lean in favor of the accused person as far as the question of bail is concerned. Under the peculiar facts and circumstances of the instant case, of the case before the trial court, this court could not but agree with the observation made by the Honorable Supreme Court at para 4 and 5 of the Hassanujaman case, to say that the circumstances cited therein are similar to the case of the accused person in question. As far since the charges are yet to be framed, even if the same are framed within a day or two, as has been submitted by the learned counsel for the respondent, for the start of the recording of evidence of the witnesses till its completion, the matter may take a few more months, if not years. Next, the reliance of the learned counsel for the respondent on the provision of section 37. As far as this instant case is concerned, again, the observation of the Honorable Supreme Court in the case of Hassanujaman at para 4 would cover this aspect of the matter. Accordingly, in view of the above, this court is inclined to allow this petition and to direct that the accused person in question be released on bail on the following condition: that he shall not abscond, that he shall, I think the usual condition, that he shall bind himself on a bond of 1 lakh with 1 surety of like amount. You have your passport with you?
No, madam.
That he shall not bound himself, then that he shall appear before the court as and when called for. I'll add some more conditions. See,
Yes,
failure to adhere to any of the conditions would allow the prosecution to refer to file for cancellation of the bail before the trial court. Petition disposed of.
Item number 8.
It is also same for the other accused.
Same case, co-accused in the instant case.
He is the petitioner himself.
Same. It's changed something. You could have 9 also same.
No, only 7 and 8.
7, 8. Then I'll pass a common order then. Common Lord.
Item number 9.
Yes.
Lordship, 9 in the last occasion they could not produce the, not they could not, actually they could, they need bring the statement of the accused and the seizure list. So court wanted to peruse to find out.
Yes, Your Lordship. I'll be providing a copy of the charge sheet to the prosecution.
In the case,
Your Lordship, on the last occasion, you had stressed on the statement of the accused person, the applicant in this particular case. It is referred here in page number 49, the last page of this particular charge sheet, Your Lordship.
Seizure list?
The seizure list, yes.
Just give me the page. You had given me in the morning, I would have gone through it.
Yes, I'm sorry about that. The seizure list is the page number 26. Page number 26 is the seizure list, Your Lordship.
yes, Mr. Khan, I think this is the case where we don't know what would be the exact situation, but from what I could understand or remember is that there are two bags. One blue bag belongs to him, and one black bag where the contraband, alleged contraband, was found. It was denied that it belonged to him. So how is the connection made?
Lordship, the only one prima facie, Lordship, PW1, his statement I read out, Lordship, he clearly makes a statement that.
Or that handyman?
No, not the handyman, Lordship. Handyman at the best, Lordship, could be an important link in corroboration. So even for the moment, Lordship, if we discard our handyman, but the PW1 statement clearly says that there were two bags were seized.
Who's the PW1?
PW1 is the police officer who was part of the investigation team.
PW1.
One minute. So Lordship, if I take your Lordship to his statement exactly at page 18.
18 of?
18 of the petition, Annexure 3. This is the second paragraph, on receipt.
Yes.
So we'll just come from the middle part. On receipt of the information, I along with the IC so-and-so, along with staff, proceeded to Latrine by so-and-so near Hill. So-and-so. At around 5 a.m., the bus bearing registration number so-and-so was detained. And the driver of the bus was instructed to park the bus at the premise of the Hillview Hotel and Restaurant. This is next sentence is important, Lordship. The bus was being searched by so-and-so and the suspected person, Sanju Singh, was found inside the bus. He was also found to have two bags along with him. Lordship, for a moment now, two bags along with him. Now this is a matter of evidence. It's an admitted fact. That's why I'm stressing on the word two bags along with him. From one bag it was seized. Now this is an evidence on record. During the trial, there are 12 witnesses. One witness has been examined. Now, at the best, if the handyman, Lordship, the handyman who has migrated to Dubai, he can't come. No, handyman will be a very weak piece of evidence, Lordship, because imagine, Lordship, I assume the role of a defense lawyer, and if handyman is in the witness box, if I ask him how many bags was boarded in the bus, where it was kept, do you maintain a serial number? He won't be able to say. How do you know that this bag belonged to him, and did you mark that Sanju Singh was the owner of the bag? He'll not be able to say. So at the best, what he says is this: he's a very weak piece of evidence. He says, I saw him carrying the bag. He's just corroborating that part of it. Seeing itself will again will not build up the case, because then did he see what was inside the bag? He says, I don't know, I just saw him carrying the bag. So inside the bag, then the witness has to show while opening in his presence, then the drug was discovered. So if you see this change of events, handyman becomes, at the best he can corroborate that, yeah, I also saw the bag. But then if he doesn't maintain the list, it would be a very weak piece of evidence. So an argument was forwarded that since handyman, the witness of handyman is being dropped and he's gone to Dubai, so the whole case gets collapsed. I'm sorry, Your Lordship, that may not be, that may be a matter of trial, evidence and argument. At this stage, if you see this particular sentence, he says 2 bags from the, along with him. The word used is very, very important, Your Lordship. This along with him, 2 bags has not been either shaken or disproved in the cross. So, and this is a matter of evidence, Your Lordship. Prima facie, Lordship is aware of it. That is a matter of charge sheet case. Now, if you come to the charge sheet that is given at page 26, Your Lordship, Caesar memo. 26. Serial number 5, Your Lordship.
Oh, referring to this.
Sorry, Lordship. The charge sheet that he has filed.
Yes.
Lordship, if you come to serial number, straight to the point, Your Lordship, number 5, from whom seizure is made. Lordship got it. Specifically, not from the vehicle. Had it been from the vehicle, then we were a bit shaky evidence. But directly the person is named. Seizure from the person. And what was seized, Your Lordship? Lordship will come to particulars of seizure. One, two, three, 4, 5, 6, 7, Your Lordship. Particulars of seizure. So, Your Lordship, at least seizure in person and the statement. It is not the case, Your Lordship, that there is no evidence at all, or we can't say what has happened. 2 back, and these are the detail from Sanju Singh. An argument was forwarded, Your Lordship, that Rahmat Ali, the handyman who saw the bag, if he doesn't come in the witness box, the whole case gets collapsed. So at this stage, Your Lordship, my respectful submission is there are 12 witnesses, 2 has been examined, and the last witness was examined on 5/12/2024. It is not the case of inordinate delay. We are in 2025. And this is a matter of evidence as to how corroboration would be made in terms of actually from. And it is not the case also, Your Lordship, had it been the case from the vehicle, we can understand. It is not the case from the vehicle, it is from Sanju Singh. So once we have this prima facie evidence, which has got an independent existence outside Rahmat Ali. Now when we read seizure list with the statement of PW1, Your Lordship, if Rahmat Ali comes to the witness box, he can say, yeah, I saw him still. I saw him carrying him. Now that would be a very weak piece of evidence, Your Lordship. Because that will not justify whether, until unless he brings the list and he has a memory of all the things. So even if supposing for the sake of argument, Lordship, even if it doesn't come, that doesn't shake the credibility of prosecution case that both the bags were seized, and this particular piece of evidence, which I read out, Your Lordship, from him, this has not been shaken in the cross. Specifically, this particular part has not been shaken. So far prima facie is concerned, Your Lordship, the section 37 comes into play and is an admitted case. Second part, Your Lordship, court will not go into appreciation of evidence at this stage, and Lordship is aware of it. Third is this, the only limited ground that he can have is 12 witnesses, 2 has been examined. The last witness was examined on 5/12/2024, whether it's a case of inordinate delay or a regular delay, and January was on holiday, we are in the month of March. So that means another 8 witnesses has to be examined. We don't have 30-40 witnesses, we have got 12. So it's no question of inordinate delay, no question of trials cannot be held. And so at this stage, Your Lordship, I don't think so a case of inordinate delay has been made out. It's not the case of prosecution is asking for time. We had a vacation of 1 month in January. So prima facie, Lordship, I don't think so this is a case for him.
Your Lordship.
Yes. Sorry, yes, please go ahead.
Your Lordship, to counter the Senior Advocate General's points, I would like to take Your Lordship to page number 20. So the learned senior had already mentioned that the 2 bags. Yes, Your Lordship. Page number 20.
20 of the petition?
Of the petition, yes. So senior counsel had already mentioned that 2 bags were found from the possession of the accused person, applicant in this particular case. Now, if Your Lordship would look at the first line on page number 20, where the bus, when the search was conducted, I have no knowledge from where the contraband was seized. That's point number 1. So from inside the bus, he had no knowledge where the contraband was seized from. And the second thing is that it is a fact that the contraband seized was not found from the physical possession of the accused person, the applicant in this particular case. Now coming to the seizure memo, Your Lordship, this would be on the charge sheet, page number 26.
Yes.
Page number 26, Your Lordship, point number 7. One receipt slip of New Life Foundation. As on our previous hearing, Your Lordship, we had already mentioned that the accused person applicant in this particular case had been a drug abuser. He is in proper rehabilitation, and after his detoxification, he was arrested. This is the same receipt when he was discharged from New Hope Center on the 31st of October 2023, one day prior to his arrest. And to corroborate this, Your Lordship, during the charge, when the charge was framed, the investigation officer, because as the bag was found from the rack, it is nowhere mentioned that, if I may take Your Lordship to point number 18 on the charge sheet.
Point number?
18. Or page number 18, Your Lordship. Page number 18. Towards the end of the bullet points, 3 points above.
Yes.
On the bullet points, a requisition was submitted to the nodal officer, Northeast, for providing the CDR of the SIM card used by the arrested accused person, Shri Sanju Singh, and the same has been received, and on perusal of the CDR, no any accused suspect could be identified, traced, who was involved in this instant case. Now, Your Lordship, the story of my applicant here is that he just got released from this particular place, which is New Hope Center, after his detoxification. Right after that, he boarded the bus. He had there's no way to connect that these particular contraband that was found from the black rack on the bus even belonged to him. Because he just got out from this particular rehab center and he boarded the bus immediately. Now, as to ascertain where this contraband came from, there are 28 to 30 other passengers who were there present on that bus the same day when I was arrested. However, none of them were questioned. It was only I, because of the fact that the handyman in page number 11, page number 32 of the charge sheet, Your Lordship. While the police was conducting search inside the bus,
Yes.
they detected suspected drugs from one black bag by the passenger who sat in seat number 28. And at the time the police searched the bus was not full. The said passenger sat at the back and he kept the backpack in the luggage rack. So this is the only connection. Rahim Uddin, who is the primary witness here, who had mentioned that this particular bag was found from the luggage rack, not from the possession. Your Lordship, I would also like to rely on one certain case regarding possession. Your Lordship, in this particular case as well, a parcel was recovered by the NDPS team. This is a case from the High Court of Bombay, Shakil Ahmed Pierre versus Union of India. This particular case, one parcel was received by the GPO, and upon investigation, it was found that one person by the name of Rahim Khan had posted this particular parcel and sent it abroad. However, it was confiscated before it was sent out. Now, during primary investigation, the statement of one particular witness, who is Dilip Khan, yes, he had mentioned that this particular accused person in this particular bail application, he was the one who had come and registered the parcel. And according to this, the parcel had gone on his name. However, the particular learned court had even examined this because of the fact that conscious possession was not from the applicant. in that particular case as well. So it shows here that on point number 15, Your Lordship, it appears that apart from the statement of Mr. Dilip Pandey, there is no material. Para number 15, Your Lordship. So it appears that apart from the statement of Mr. Dilip Pandey, there is no material to connect the applicant with the said parcel or lend support to the version of Mr. Dilip Pandey. Now, even in my case also, apart from the statement that Rahim Uddin had seen him carrying the 2 bags, nobody else had seen. There's no other independent witness to tie those particular bags. And Your Lordship, as we have already mentioned, it's a commercial vehicle. 28 to 30 passengers are already there inside the bus. It could have belonged to anyone. The suspect could have even been there. However, due to only the information that was provided and based on the investigation that was done, only my accused person, the applicant, was implicated in this particular case. So Your Lordship, based on the facts and circumstances of all the cases, of my case specifically, and because of the mere admittance of Rahim Uddin being the only eyewitness in this particular case who has been dropped by the Honorable Trial Court, and there's no other evidence to link this particular case to my applicant. So I kindly pray that I may be enlarged on bail, as there's no other evidence that would corroborate any other story apart from Rahim Uddin's, Your Lordship.
How long have you been in custody?
1 year, 4 months and 10 days, Your Lordship.
I've heard the parties. Okay, I'll pass the stay orders.
Lordship, just one small submission, Your Lordship. Lordship, just one small submission, Lordship, because charge sheet was given to me hurriedly just right now. Lordship, kindly see page 33 and 36 also. 33 is the driver. Charge sheet, Lordship. 33 is the driver at the, from the bullet point, Your Lordship, from the bottom, 1, 2, 3, 4, 4 and 5.
Yes.
4 and 5, Your Lordship. So it's not only Rahimuddin, the driver of the vehicle. Now what does he say? It's a matter of evidence, he has to be in the witness box. When the police conducting search bus, they detected a suspected drugs from one black color backpack owned by the passenger who sat at seat number 28. So subject to evidence, Lordship, not to say admitted facts, who is 28. At the time of the police search inside the bus, since the seat was not full, the said passenger sat at the back seat and he kept the baggages in the luggage rack. This is driver, Your Lordship.
It's yet to be examined.
So the statement of PW1 can also find credence here. And then, Your Lordship, page 36.
Yes.
Now he is working as a hotel Hillview restaurant. He's got no interest. He's not a police witness. Lordship, what does he say at 1, 2, 3, 4, 5, 6, 7? During the search inside the vehicle, one black color was found owned by one Sanju Singh. Was checked and found inside the backpack 3 brown pamphlets, and which was packed brown color and with sellotape. On opening the 3 brown packets and found blue color sachet inside, and these blue color sachets were found to contain orange pink tablets. Thereafter, the police conducted tests in the orange pink tablets, so and so. This part, Lordship, next part is very important, Lordship.
Yes.
I was present when the police seized.
So he's a teacher witness.
Lordship. So he's narrating who owned the black bag, what was found inside, and he mentioned Sanju. And then he says, I was present when the police seized the suspected bag and mobile phone from the accused person. He's an eyewitness. Lordship will kindly see the quality and credibility of this witness. He's not a police witness. He's a Hillview, and he has got no interest out of so many people to mention him. So Rahimuddin, for the time being, the only argument forward is irrelevant in virtue of 36, 33, driver, the Hillview owner, and then the police statement.
Your Lordship,
There is no two agreement on the C28, no two agreement, and these are all matter of evidence, Lordship, which is yet to be tested and decided. As my submission, my final conclusion would be, Lordship, out of 12, two has been decided, and it's not the case of inordinate delay or trial being derailed.
Your Lordship, before only one small submission with regards to all these statements that have been given by the police. These are all just statements under 161, Your Lordship. We will be able to prove that our innocence by
that is
before
always
trial.
there.
Yes. However, on the charge sheet, Your Lordship, this is the charge sheet that has been made by the particular SI, the IO of this particular case. He had specifically mentioned on, if Your Lordship may kindly refer to page number 17 of the charge sheet, on his brief facts of the case, on the point number, the second point, where here he clearly mentions that only Rahim Uddin was the first link person to actually link this particular bag with my accused person, the applicant. It says here, during search, page number 17, Your Lordship. During search, the suspected drug peddler was identified and he was carrying along with him two backpacks, one black color and one blue color. The two backpacks were being identified by the handyman. Here, this is the IO who had gone and investigated and found the bag. He is the person who also mentioned that the two backpacks were being identified by the handyman. Of the above mentioned Night Superbus Shri Rahim Uddin, that the backpack belongs to the suspected person, Shri Sanju Singh, and the handyman told that he saw the suspect brought the backpack while entering the bus. Now, this is the first story which got to the IO.
I think that has been discussed
Yes,
at
Your
length
Lordship.
as to the credibility of
Yes, Your
his
Lordship.
evidence.
Yes. I will only stress on Rahim Uddin, Your Lordship, on the statement of Rahim Uddin.
Oblige, Lordship.
Obliged, Your Lordship.
I've got the party. I'll pass on the orders because
Lordship.
I think I have to sit in the
Yes, Your Lordship.
division.
Second call, item number 1.
May it please your Lordship. I counsel on behalf of the petitioner, Waris Uddin Laskar, who is the paternal uncle of the accused person, Zahin Hussain Laskar. My lord, that the fact of the case that on the
I think
26th,
we'll take up this matter some other day. Because of time constraint, I don't think we'll be able to take it up today. You suggested, or you're going back
yes,
today.
yes, my lord,
You can always appear online.
Tuesday.
You take it up the second.
To suggest today.
Sorry?
Wish to suggest today.
We have done it.
Day after. Day after.
Okay, see.
Day after.
Singkat betul kita. Wait. We'll take it up on Monday then. You can either if you can come personally or you can appear
Through EC.
through BC. It's up to you.
Oh, all right. Much obliged.
On pre-made by the parties, let's this matter on 17.
All right. Much obliged.
इसको फोटोकॉपी कर लो